everyone. I am so delighted to be here with you, and I'm trying desperately now to find my, the clicker. Because I was texting with Jessica last night and saw that there was a podium. I go, you know what? I'm not really like a podium person, because I talk with my hands and I do things like knocking stuff off the podium. And I like to get closer to all of you and look at all of you and be able to register your feedback as well. Let me begin with the fact that this is me. Luckily, I don't have the same outfit on. It wouldn't have been unusual. But this is my field, talking about issues of sexual equality and sexual violence and sexual harassment and safeness within our higher education communities is what I've done for the last 35 years. I was the Associate Dean of Students at Ohio State University. I did campus conduct there, but I also, throughout part of my career there, was responsible for the Office of Women's Services, the development of the LGBTQ office, and was all offices that were focused on the rights of an individual, the empowerment of an individual in the environment. So, I don't come to you today just having been trained in doing this, but with my heart and with my passion. The other piece of my heart, which is, I've got to sort of confess to you, is the great Northwest. I love it so much. In fact, I'm convinced that I was probably part of the original settlers, or not settlers, pre-settlers here, because when I come to this area, there was this soothing of my soul that I don't get anywhere else that I go all over the country. So I'm delighted to be here, and it's really fun for me because I have some long-time friends and colleagues in the group. And my hope is that by the end of the day today, many of you will be part of that circle of friends as well, that when I go to sessions or go to trainings, I will be thrilled to connect with you and see you again. I know most of you have immersed yourselves in issues related to sex and gender discrimination and sexual misconduct, particularly over the last year and a half since the Dear Colleague letter came out. And my expectation of what we're going to do kicking off this morning is going to be to start with just an introduction of those foundational pieces. I call them the game changer cases. And we're going to move really quickly from there into the expectations that are set forth for us through federal law and what that means for us. Now, one of the things that is important that all of you know is after I received the list of schools that were going to be present, I went on every one of your websites. And when I go on your websites, I go on your website as the 21-year-old female whose best friend just walked into the room and said, I need to tell you something. And sometimes what they need to tell me is, I've been going to class, and in class, my professor has focused in on me in a way that is so uncomfortable and started making me feel guilty if I'm not there, like this was a she, like he is taking it personal. And then he has begun texting me and emailing me. What should I do? Who should I tell? Where can I get help? Is someone going to believe me? And then I'm the 21-year-old student whose best friend walks in the door and says, so I went to a party last night. Had a great time. Met the coolest guy there. Had a lot to drink, I know. And we went back to his room. And the next thing I remembered or realized was it was 7 o'clock in the morning and I was naked. And it was obvious that I'd had sex. And again, my friend is saying to me, where do I go? Who do I tell? I don't want to get in trouble. Or I don't want to call my parents. But I need to know what to do. And what I want to talk with you about today is breaking down those barriers so that your school is providing that information. One of the things you'll see at the very end of our presentation is what I call the Saunnie's 3-click rule. If I am in either one of those situations as the friend of the person who comes to me, I can tell all of you as institutional administrators, you get a 3-click chance for the student to find a source on your campus to answer those questions. And they usually do it with this. They're not going to go, oh, I remember them giving me a brochure. Where did I put that brochure? They're going to go here. They're going to go to your website, and you get 3 clicks from that point for them to find the information. And I want to share with you as well, I couldn't find it in 3 clicks on most of your campuses. So I want to issue a challenge to all of you that you strive toward working on that 3-click rule, because that's one of the ways that we're going to be able to do our reach out to students. It's less important that they hear from us about the good things we do and that we believe that this is wrong. Really? You weren't going to write that it was a good thing, were you? But so many of you take up an entire paragraph talking about why we believe it's wrong, and I want you to do that. But keep it simple, because what they want to know, and this is what students, by the way, all over the country tell me. If I'm at your school, by the way, for more than 2 days, I will always ask to have a 2-hour period of time with students. Generally in the evening, I generally ask you to provide pizza, and we get students in, and none of you are invited. Because it's the conversations between the students and I where I start to hear what's important to them. And the 3-click rule was important. But here's what they said loud and clear. We really appreciate it when the schools have good policies and when they've got solid procedures. But we're not going to read it. And I said, well, how can we help you? How can we provide the support for you? And the students say to me, you tell me what we need to know when we need to know it. And so one of the areas of advice that I always give to schools is gather your students together, find out what's important that they know, and then deliver that via your website in the vehicle that they will take it in. So don't just make assumptions about how we need to create something. You're all in great positions as well as knowledgeable about putting together really pretty websites and informational ones. And they may or may not answer the questions that our students want to hear from us. So I encourage you to start it from there. Let's first of all take a look at Title IX, because I bet I may be starting to change some of your focuses today. Because we begin with this piece right here. No person in the United States. What it doesn't say is no female person in the United States. It also doesn't say no student person in the United States. It says no person. So the first thing I want you to realize is that this is not a women's law. Has it had a tremendous impact on the empowerment of young women, particularly in athletics? Does it continue to have a tremendous impact on women, because we know that 95% of the cases that we get, the woman is the victim? Absolutely. But it is not a women's law, and it's not a victim's rights law. Title IX is an equity law. It talks about people not being excluded from participation in or denied benefits of or discrimination under any program or activity of receiving federal financial assistance. I want you to recognize that when you've got a faculty-to-faculty situation in which we will address typically through a different federal civil rights law called Title VII, and I'll do a couple slides on Title VII, that does not mean that Title IX is not an applicable federal civil rights law as well. So I'd like to begin with that idea that The law itself talks about no person. It doesn't talk about no women or no student. Let's briefly go through what I consider phase one of the game changers. And of course we begin with Franklin v. Gwinnett, 1992, 20 years. And you all know, of course, but you would have been asleep if you had missed that this is a 40th anniversary year of Title IX, because it got so tied in with the Olympics that every time you picked up a newspaper, you saw, 40 years, Title IX. But for the first 20 years of the law, it was viewed exclusively as, with discrimination being described as exclusion based on sex or gender. And then this young woman, Christine Franklin, changed that. Christine was in the 8th grade when she had her absolute favorite teacher, English teacher, who encouraged her to connect with her husband, with the teacher's husband, who taught advanced communication, and thought that her husband would be a wonderful tutor and mentor for her. Well, the husband had different ideas about what mentoring meant, and in 1992 he began calling her at her home. Now recognize, pre-cell phones, pre-computer, so it wasn't the texting and the emails. He was actually calling her at her home. And then he became so bold that he would give her classroom teacher a note asking her to be excused. And when she was excused, he would take her to an empty classroom or an empty office where he raped her. And Christine told her parents about it, and she told the school about it. And the principal of the school gave her the same words. In fact, when I was getting ready this morning, I was listening to the interview of one of the young men that was a victim of Jerry Sandusky. And he described almost identical to what happened to Christine Franklin. He went to the school, he and his parents. They told the principal what happened, and the principal was very skeptical about it. The principal asked her what she did to interest this very well-respected teacher in this sort of salacious kind of way, if it was true. And then the principal told Christine and her mom that they really need to just go home and think about it a little bit and see if they could work it out. Well, what they ended up doing was filing a lawsuit. They filed a lawsuit under a Title IX premise. And the school's response is, this has nothing to do with athletics. She was not removed from a program or an activity because she was female. This has to do with sexual activity, which is really nothing to do with Title IX. And the trial court agreed with her, or agreed with the school. And so Christine and her mom persisted, and they appealed it to the Court of Appeals. And the Court of Appeals said, really, Title IX, see, it talks about this. It talks about being excluded from participation. And it talks about subjected to discrimination in program or activity. It really doesn't talk about sexual-based behaviors. You've gone the wrong route. You really need to file a complaint against the teacher and not the school, for heaven's sakes. Because we're responsible for Title IX, but we're not responsible for what happens in these personal situations. You've got a tort claim. And they persisted and they took it to the U.S. Supreme Court. And the U.S. Supreme Court did two absolutely game-changing landmark decisions in this case. They said, number one, that if an individual's been targeted because of their sex or gender, and that targeting is of a sexual nature, so that the impact of it results in this, in being excluded from participation or education. Because recognize that Christine stopped wanting to go to school. She was terrified. She had no support structures there. And so the court said, it has the same impact. It has the same kind of discrimination as if she were specifically excluded. And so it was the first case that we saw 20 years after Title IX was created. The very first case we saw in which the highest court in the land said behavior that's directed towards someone of a sexual nature. And they coined the term sexual harassment to be all-encompassing of the whole spectrum of behaviors, is going to fall under Title IX. And the next piece that they agreed to, which the school of course had argued about, is if you have been a victim of that, then you're entitled to monetary damages. Because the school argued, Congress did not specify that the funding recipient, the school, should have to pay dollars. And the U.S. Supreme Court said, yeah, but they didn't say that they didn't have to either. And so these two elements really set us on a very different course 20 years after the creation of Title IX. The next two cases came 1-2 shots in 98 and 99. I know you're familiar with it, but I have to mention this is Gebser versus Lago Vista. It also involved a student and a teacher that were having a sexual relationship that began the summer that he was part of her tutoring group. And it continued through a 2.5-year period of time. Now, sadly, really pathetically sadly, the U.S. Supreme Court refers to this relationship as a consensual relationship. Alita Gebser was 15 years old. My hope is what they were trying to distinguish it was that although it certainly was not consensual because she was a minor, that she was not protesting. She was a willing participant in it until the point in time that they were caught having sex in his car in the parking lot. And you would think at that point that the firing and everything that occurred would be through his sheer stupidity. But the reason that they filed a lawsuit in this case is because after they fired him, they didn't come back to Alita and say, what do you need for assistance and support and remediation? What have you lost over the period of years in the education context that we need to be providing support for? And so the U.S. Supreme Court 5-4 decision, by the way. In both of these cases, Sandra Day O'Connor was the individual that wrote the decision. And she said, yeah, we should hold schools responsible for it. Because in the Franklin v. Gwinnett case, they made this ruling, but they didn't say under what circumstances the school would be held responsible. So 6 years later, they did. And they set a very high standard. They said that there must be someone at the school that had actual notice. That individual had to have the authority to take corrective measures, and that the school failed to respond properly. They used the term deliberate indifference, that the school behaved with deliberate indifference. And guess what, in this case, by the way, Alita Gebser lost the case. And the reason she lost the case is because it didn't meet the standard. The school did not have actual notice that this teacher was engaging in an inappropriate sexual relationship with a student. So it failed on the first prong. But they did set the standard for it. This case, of course, deals with the employee to the student circumstances and institutional liability. And then 1 year later, we got the student-to-student case. And for those of us that worked in student services, it really changed our world. Because we began recognizing that in cases involving student-to-student sexual misconduct, and I want to start using that as the broad continuum that incorporates harassing behavior up through and including non-consensual penetration, that they use the same standard. In this case, by the way, Davis v. Monroe County, LaShonda Davis was a 5th grade student. And there was a young boy in the class who bullied her persistently, who touched her private parts, who said that he wanted to fondle her boobies, who sent her lots of notes. And in this case, LaShonda and her parents went to the school multiple times. And the school, it took them 7 months of the parents complaining before the school ever separated the two of them from sitting next to each other. And it was finally at the point in time when the teacher had the little boy escort her to gym class, LaShonda to gym class. And he pulled her behind the stairs, he pulled down her pants, and he fondled her. And her parents said, enough's enough. By the way, the dad also read LaShonda's journal in which she said she'd rather kill herself than keep going to school. Because, again, she felt that no one heard her. No one cared about it. One of the school's responses is, look, we've punished him, we've sent him to Saturday school, we've talked to him about it, but these are 5th grade kids, and you're making a big sexual thing out of this, and 5th grade boys are going to be 5th grade boys, and you need to recognize it. And the parents said, actually, we don't. And so this case, too, went up to the United States Supreme Court. In this case, Monroe County Board of Education did lose the case. But the important takeaways for us was not the winning or the losing, but the messages that came from it. And some really important ones. Number one, the court reinforced what they had set forth for institutional liability in the Getzer case. And in that case, of course, they said there must be someone that has authority to take action, that we have actual notice, and that we demonstrate deliberate indifference. But Justice O'Connor went on to give us what I consider, for people who work in this field, the most important message at all. In fact, that message is done really pretty and framed in front of my desk. It says that deliberate indifference is behavior that is clearly unreasonable in light of the circumstances. She took us to a different level in that case. She moved us from saying deliberate indifference, which basically means if we learn about it and don't do anything, we're deliberately indifferent. And Justice O'Connor said, don't put the tackle on you. You have a responsibility to look at the totality of the circumstances and make a reasonable response to what you've learned. So I want this to set the tone for us for the day as we're talking about the cases and the circumstances, and we're talking about reporting requirements, and we're talking about other institutional obligations, that you recognize that what we give you, what you've got from OCR, is that framework to help you measure what's clearly unreasonable in light of the circumstances. And we use that as our measuring line. So what governs sexual misconduct responses? Always has to start with your college policy. You all did good jobs on articulating your college policy, particularly in beginning that piece with articulating what is your culture. What is the mission? What do we believe in? How does that frame how we deal with students? And then, of course, I wanted to reflect the law. I'm going to go through some specific elements that the Office of Civil Rights has given us as the roadmap for compliance. And I really want to emphasize it because, again, after having lots of conversations with Jessica and learning that we've got a well-educated group here, when I looked at your policies and your grievance procedures, I said, you may have a well-educated group, but they haven't been paying attention to what OCR says we need to have as part of our protocol that we articulate to students. So the next piece that we're going to talk about is Title IX. And there's a yin and yang on Title IX. First is the case law pieces. Remember, for case law, actual notice, someone that has the authority to take action, and we don't demonstrate deliberate indifference. And by deliberate indifference, that means we look at the totality of the circumstances and we behave reasonably. OCR gives us the roadmap, the guidelines for compliance. They're an administrative agency. They don't have authority to issue fines against us. I mean, they can do the big stick of removing federal funds if we refuse to comply, but they're the administrative body, a different set of standards. I put in Title VII because there seems to get confusion with it. Title VII is another federal law, another federal civil rights law. It doesn't apply to our institutions because we accept federal money, like Title IX and FERPA and Title VI do. Title VII applies to us as it does to corporations. It says if we employ more than 15 people, we can't discriminate against individuals based on sex, race, religion, or ethnicity. And they give us guidelines as well. Those guidelines are provided by the civil rights entity for the Department of Labor called the Equal Employment Opportunity Commission. And the two laws tie into each other very carefully. It's not one or the other. The final federal law is the Clery Act, Campus Sexual Assault Victims Bill of Rights. Just as I said, Title IX is not a victims' rights law, it's an equity law. It's a civil rights-based equity law. The Campus Sexual Assault Victims Bill of Rights is an element of Clery, a federal law, that is victim-focused. And they do have the authority that was given to them as part of the regulations that were created. And by the way, it's just been increased. They have the authority to fine an institution $35,000 for each violation of Clery Act, whether it be reporting or following through on the Victims' Bill of Rights elements. So we begin with Title VII versus Title IX. As I said, there seems to be far more confusion than there needs to be. This was an early law. The Title VII really was one of those laws that was part of that very early civil rights law development movement in '64. It's provided oversight by the Department of Labor, and it deals with, the discrimination elements in the workplace context. In contrast, Title IX was enacted in '72. It's overseen by the Department of Education because it applies to entities that accepted federal funds, and it's overseen by the Office of Civil Rights. Here's the language for Title VII. Just want you to see it and have the citation to it. Prohibits discrimination in the terms, conditions, or privileges of employment based on sex, race, ethnicity, or religion. And then, of course, like all the civil rights laws do, it also prohibits retaliation for someone who would engage in reporting or serving as a witness. Title IX, in contrast, applies in all areas of education. It's not just sports. It's not just student-to-student relationships. It's all areas of education that impacts sex or gender. I use those terms separately because it's important that we understand it's not sex as in sexual acts only, but it's also if an individual has been targeted because either their gender, as in male or female, or perception of their gender, or gender manifestations, or gender identity. And so it's applicable to those situations where someone has been targeted because of the manifestation of the gender identity that they express, or an individual who has been targeted because they are either transgendered or in a transgendered process. So Title IX is expansive in the whole sex and gender area. And the important piece is it applies to issues of program equity, athletics, student organizations, admission into programs, but it also applies to harassment and assault. I want to talk a little bit about the Clery Act because frankly, we can't talk about the way in which we do Title IX compliance without the acknowledgement of the impact of the Campus Sexual Assault Victims Bill of Rights. This was a law that passed in 1990, again, to schools. If we receive federal funds, we enter into an agreement to comply with the Clery. And then in 1992, the Sexual Assault Victims Bill of Rights was created. And I find this very interesting. It was developed to combat the re-victimization of rape survivors at colleges, campuses across the country, who found that many image-conscious schools were more concerned about protecting their image than seeing justice done. And in preparation for today, like many of you, I reread the Free Report. And when I was taking a look at these elements, when I was reading the Free Report, it just sent chills up my spine because I thought about the re-victimization. And you know, it talks about victimization and re-victimization, and the re-victimization oftentimes comes from our ineffective reporting. And we're going to be talking about that. What does that mean? How do we support a victim but engage in not re-victimizing that individual or the next individual? So the re-victimization applies not only to the initial individual, the survivor of the initial behavior, but also to other individuals who maybe subsequently find themselves victims of some form of sexual violence. Here's what the law requires: that all colleges and universities participate in federal fund, provide programs that afford certain basic rights. And I talked about the $35,000. These are checklists for you. I'm sure you're all aware of it. You've seen these for, what, the past 30 or 20 years? Number one, you got to have a statement about the programs of prevention and the procedures to follow when a sex offense occurs. Programs for prevention, you're all pretty good at having listed that. I go back to being the friend of the person who was a victim, and I couldn't find what that process looked like on many of your websites. Again, a description of the programs that promote the awareness of rape and acquaintance rape and forcible and non-forcible sex offenses. Just as a review, a forcible sex offense is described as sodomy, rape, any form of non-consensual penetration or contact. Non-forcible sex offenses really are only two categories: incest, sex with a minor. So Clery, following the FBI standards, use this forcible and non-forcible sex offenses or categories. We have to identify the students what procedures should they follow if a sex offense occurs, including who should be contacted, the importance of preserving evidence, and to whom the offense should be reported. We have to provide information about a student's option to notify law enforcement and the fact that we'll assist them in doing so. We have to provide notification for both on-campus and off-campus counseling services. And we have to provide information to them that will change a victim's academic and living situations. Now, as I started talking about Title IX, which under OCR guidance, we recognize that OCR gives us a roadmap, not a law. It tells us what we need to do to comply with it. But you'll see that the Victims' Bill of Rights created in code, in law, that many of the things that were mandated and required to do under Title IX. Procedures for disciplinary action, the sanctions that the institution may impose following a final determination. A statement that the accuser and the accused are entitled to have others present during a disciplinary hearing. And a statement that both the accuser and the accused must be informed of the outcome of any institutional disciplinary proceeding. I want to begin our discussion in terms of reporting and responding with this, because it starts to become confusing, and I'm hoping that we'll have lots of conversation about it. Under Clery, if it is a forcible or non-forcible sex offense, so if it is an offense that involves assault, rape, sodomy, non-consensual penetration, or non-consensual physical contact, it's going to fall under a forcible sex offense. And Clery defines outcome as including the determination, the sanction, and the rationale. That both parties are entitled to know under Clery if it falls into the forcible or non-forcible sex offense. I want you to read this carefully with me too. Informed of the outcome of any institutional disciplinary proceeding. It is not limited to disciplinary proceedings between the students. So when you've got any circumstance, whether it be faculty and staff and a student, faculty and staff together, if you've got a situation that involves forcible or non-forcible sex offenses, the complaining party is entitled to three things in writing: the outcome of the decision, the rationale that was provided, and the sanctions that were imposed. We've seen this shift in focus as we talk about it. You see Dean Wormer. How many of you remember Dean Wormer? Yeah, just a few of you do. How many heard the movie Animal House? Yeah, a little bit more of you do. Well, you know, in Animal House, Dean Wormer was really angry at Bluto. And he said to him, "You're out of here." And Bluto goes, "I didn't know I did anything." He goes, "Are you kidding me? You've been on double secret probation for the last year." And he was kicked out of school. And that was in the 1950s, and we called that in loco parentis because the schools had the authority to do whatever they wanted. And they abused it. And then in 1961, Dixon versus Alabama, 3 African-American young men had the nerve to sit at a local luncheonette that was reserved exclusively for white people. They were demanded to leave, and you know what they did? They didn't leave. And the governor called the president of the University of Alabama, and he goes, "I want them out of school." And the president of the university argued, actually, quite a lot with it, but ultimately removed them from school. Ultimately did a Dean Wormer. You sat at the luncheonette. You're not allowed to do that. You're black. You have the business theme there. You're done. You're out of here. And these guys, with a little bit of help from people that cared, decided to fight back about it. And that began the era of saying, if you go to a public institution, you develop a property right, as in life, liberty, and property, 14th Amendment, constitutional provision. And you can't be removed once you've been admitted and remain in good standing without due process. Without due process of law. No, at minimum, notice and an opportunity to be heard. That's what they told them in Dixon versus Alabama. And from 1961, really until the Dear Colleague letter came out, we, and I say we because I was a campus conduct officer for 15 years, we built great temples of disciplinary procedures. I know what ours look like at Ohio State, and I know what a lot of yours still look like. They're phenomenal temples for due process, because Lord forbid that we would remove someone without just these huge, elaborate opportunities for the accused individual's due process. And let me tell you what happened along the way. We forgot the individual that brought the complaint, that oftentimes was a victim of a traumatic sexual act, whether they were traumatized because of the behavior of a professor in a classroom, or whether they were traumatized because they were the target of non-consensual sexual penetration. We overlooked them. In fact, we said things to them like, well, this is our case. And so you can come in as a witness and listen to that portion of it where you give testimony. And then you can be excused, and because it's our case, we'll take it on from there. And in fact, one of my schools, which will remain nameless, and it might be in Iowa, but it might not. 2 years ago, when I was on their campus looking at their procedures were something like this, that a case of sexual misconduct is the institution's case, that the complainant is identified as a witness and may be accompanied by someone from the institution. The accused is entitled to be actively represented, not accompanied, actively represented by an attorney. And when I saw this and nearly fell off my chair and said, why? And what I realized was they had really created a structure that replicated our criminal process. Their response was, because we're prosecuting this student. And this is the University of a school in the Midwest that is prosecuting a student. And how can we prosecute the student without giving them full measure of due process rights? And I said, what about the person that's the victim of the behavior? Well, we represent them. And I go, seriously? So what I'm hearing now is, if I'm a victim of sexual violence of some sort, I have to rely on you representing me, A, and B, that you've picked sides and that you're prosecuting the student. If any of your systems are set up that way, go home with a big eraser and get rid of it. I mean, it's just unacceptable. Number one, we don't prosecute students. When I do my investigation training, I have another big slide that I say to investigators, print this off, keep this with you. Because our job is to protect the integrity of the process. Our job is not to pick a side. It is to protect the integrity of the process. What we started seeing in the Dear Colleague letter was a two-sided thing, and I think it's caused a lot of challenges as we're engaging in the analysis of this. And one is that we have to investigate. We get put on notice, we investigate. And I want to make it clear that that investigation takes many forms initially. I like to call it the inquiry piece, where we gather enough information to make a determination of, A, is this, would this violate one of our policies? And B, is there sufficient information that we need to begin to engage in a more deep investigation, where we call people in and we engage in discussions and we talk with witnesses and we gather information. But also the Dear Colleague letter, well, on the one hand they said, you got to report, and because you have to investigate. On the other hand, they said, but there's going to be circumstances in which an individual says, I don't want my name used. I don't want to participate any further. I don't want to go any further. And as a team of people at universities and colleges, we have got to be sensitive to the fact that we can find that balance. It's not a bright line. And that balance typically is going to fall with your Title IX team, who's going to take a look at a lot of circumstances. Let's say it's before we know the name of the individual that was the recipient. And by the way, oftentimes I use the term victim. Sometimes I use the term survivor. Sometimes I use complainant. It's all intended to describe that individual that is the recipient of the unwelcome behavior. And so, I'm just going to try and thought for a second. So we've got this information, and how do we do that to honor and respect the rights of that individual? Well, number one, your Title IX team, my expectation would be, they would take a look at the nature of the information that was reported. And they would say, let's begin with the premise that the person that was a recipient doesn't want to participate. Well, what kinds of things would mitigate against our not being able to honor that? Well, if it was violent behavior, if that person were at risk for continuing behavior, if it was behavior that suggested this may be predatory. And as your Title IX structures become better developed, you're going to be able to look at the information and say, well, this represents a pattern. We need to go back and get additional information. But if also you've got the fact that this occurred and the complaining party does not want to participate any further, can that happen in a way that allows us to engage in the obligations? And whatever are our obligations, I think it is right here, those four at the bottom. Those are the absolutes. Those are the things that you're going to be measured on. You're not, by the way, you're not going to be measured on how effective your campus conduct process is, or even how effective your structures are under Title IX. You're going to be measured on, did you investigate? What did the investigation look like? And as I said, that investigation takes a little I and a big I view. The little I is, was there enough information for us to go forward? And if so, did it potentially violate one of our policies? And then you put those elements into it. Was there a level of violence that suggests the person may be at risk? Was there a pattern of behavior? Was there behaviors that seems to give us concern about the rest of the campus, the victim number 2 in this case? So that's the purpose of our engaging in investigation. And honestly, we can begin that process without the identity of the complaining party if we don't, at least initially, if they do not wish to give it. Then they say, you gotta do 3 things and you gotta do them well. Number 1, you have to take prompt and effective action to end the harassment. And again, look at harassment along the continuum. We could also say to end the sexual violence. Number 2, we have got to be able to remedy the effects on the complaining party. Now, the degree to which someone's willing to participate in terms of having their name known will have an impact on the degree that we can engage in effective remedial support. You know, we can't do a no contact letter if we can't use the name of the complaining party. We can engage in some degree of housing accommodations. We can certainly engage in academic-based accommodations. But the remedial effects have got to be addressed. And then finally, all the actions that we take must be designed to prevent the recurrence. If this goes to a hearing board, that must be one of the elements that a hearing board engages in asking the question, is our actions that we take, if we find a person has violated our policy, is it going to be effective in remedying or preventing a recurrence? I always say to hearing boards who, let's say they find someone in violation of non-consensual sexual penetration. It was drunk sex, we couldn't determine exactly what happened, but we think something happened, and so we think he was just confused, that he didn't understand consent. So we found that he violated the policy, but we put him on probation. Or we told him he had to be away for a term. I would want all of you to think when you're doing that, or when you're working with hearing boards and doing that when that person either remains in the environment or returns to the environment, that you feel completely comfortable to fix them up with your sister, your daughter, your best girlfriend. Because that's what you're saying to the entire rest of the campus. Yeah, we think it was just one of those situations. They just, missed communication. Maybe they did. Make sure that you're comfortable enough about that you would connect them with someone that you care deeply about. Because that's the elements that we need to be concerned about. Again, OCR is going to take a look at the compliance standards that we create and the fact that if we have noticed, these are the steps we must take. The OCR creates those regulatory standards, and as I said, it says that they're our responsibility whether or not the student who was harassed makes a complaint or otherwise asks the school to take action. This equates to notice. Sometimes actual notice, sometimes constructive notice. Remember, to file a court case, you have to have actual notice. But OCR says, we can't fine you. What we want you to do is be in compliance. We want you to do the right thing. And so we're going to set a higher standard. We're going to say if you knew or should have known about it, you're going to be responsible for engaging in an action that addresses it. They also, by the way, and I want you to do the same thing, they apply the severe, persistent, or pervasive. You've seen severe, pervasive, or objectively offensive, and those are not in conflict with this. Basically, the objectively offensive standard simply means that a reasonable person in those same circumstances would have viewed it to the same extent that the complaining party did. Camille and I may be in a class, and I am so greatly offended by the comments and the jokes or the references or the actions that the professor's taking that I genuinely feel that I'm in a hostile learning environment. That's my subjective approach or my subjective response to it. I make a report to the dean and I go, this just can't continue. And the dean goes, well, I want to make sure that I've got a good perspective on it. He talks to Camille. And Camille says, yeah, the professor did all those things. It didn't bother me. Camille's subjective opinion or subjective action is that, no, it didn't bother me. So as making a determination, I would need to decide, was Saunnie being overly sensitive? Was Camille just, that kind of thing did not bother her? Where does it fall? What would an objective person in that circumstance have responded? And so using the severe and persistent standard in conjunction with the reasonable person standard is where you would need to go in making those determinations. Now, let's go down to the third bullet, because this is the one I think becomes important for us to consider, that there's not that bright line. There's going to be circumstances where the complainant requests confidentiality or refuses to participate, and therefore our school's ability to take action may be limited. A couple things on here. I hate the word confidentiality. I just hate it. And the reason why is if I tell Colleen something and I go, can we keep this confidential? And Colleen goes, absolutely. I'm your RA, I'm going to keep it confidential. Well, what Colleen knows is that confidential for her, and generally that's what OCR uses, is that confidentiality is conditional. That what Colleen's going to do is she's only going to tell people that have an absolute need to know that might be able to help her help me. But when Colleen tells me that she's going to keep it confidential, you know what I think? I think Colleen's not telling anybody. And so look at your policies, look at your things that describe confidentiality, that say we'll keep it confidential, because students take that as gospel. They don't think you mean confidential under the circumstances that the only people that are going to know about it are ones that need to know. Because I want to tell you what confidentiality, the translation of what our students use is actually called privilege. And privilege is provided to us through state law. Our state laws, and I looked up the Oregon law, and Oregon law gives privilege to social workers, to mental health therapists, to physicians, to lawyers, to clergy, all of whom, when they are engaged in the duties related to it, not because they've achieved that academic standing. So if someone is a mental health therapist, but they're working as an academic advisor, they don't have privilege with the students in the circumstances. When you use the word confidentiality, students interpret it as it's going nowhere. It's staying with Colleen. Colleen's not going to tell a soul. Be very careful about that word. they're going to ask, a student may ask you for it. You need to let them know what the context of that means, because you can't assume that they do. And one of the worst things that can happen is Colleen saying, well, of course I'm going to keep it confidential. And it stops there, and Colleen tells her hall director, who says, you know, I'm concerned about this, and we need to, number one, we have to let our Title IX officer know. Because it's, the Title IX officer must have the 100-foot view of all sex and gender misconduct on our campus. And then, so the Title IX officer and the hall director talk about it, and they go, wow, based on the circumstances, you know, this is the 4th time we've had a complaint from this fraternity house, student organization, athletic club. We're going to need to get more information on this. I'm assuming at that point no one else knows about it but Colleen, because Colleen's told me she'd give me confidentiality. I want you to be careful, because here's what I'm going to feel. I'm going to feel betrayed. I'm not going to trust you anymore. And the amount of time that it would take for Colleen to say, I'm going to keep this information as private as I can, but you need to understand that because the school has an obligation to protect you and to protect other people, this is who I'm going to have to share this information with. And your institutions can make the determination of if Colleen, as the RA, must at that point in time give the name of the victim. That's institutional decision. But the information must be shared. And my partner, Brett, calls this picking number one domino at a time. That Colleen can retain the right to, must report, but may retain the right to only knock over that one domino, that is the reporting of the incident, and further dominoes may not be knocked over. In other words, we don't have a runaway train with an individual who says, but I didn't want any of this, and this is why I didn't tell people. So we've got to be very, very careful about it. And then they go on to say, there's going to be circumstances of the complainant requests confidentiality or refuses to participate, but we're still required to do what? The 4 things. Investigate, stop the behavior, remediate the impact, and reasonably prevent the recurrence. That's our measuring stick. When we talk about understanding victim focus, and one of the things you hear a lot is victim-centered approaches. I know I certainly hear that a lot from my partner, Brett, a victim-centered approach. I want to make certain that we put it in a context. That, as I said, Title IX is an equity law. And equity means, is it fair under the circumstances? And so a victim-based response doesn't mean that we weigh the scales differently. Remember, we've got those 4 obligations. But a victim-based response means that we have gone from the Dixon versus Alabama absolute, castles to due process, to recognizing that a victim of a non-consensual sexual act of any kind is entitled to rights under the circumstances as well, beginning with the obligations of the remedial support and the recognition that it's not a matter of creating a bias for the victim, but acknowledging that by the very act that the victim has reported to us, they are experiencing a deprivation of rights that we should be providing to them. This is an educational environment. Students should be free from learning environments that are oppressive or discriminatory in nature. So we've got to recognize when we talk about victim-centered or victim-focused or victim-friendly, it's not a matter of we're overlooking our obligation to maintain the integrity of the process. It is simply the acknowledgement and the recognition that there has been a deprivation of rights, and it's important for us to acknowledge that. I put this little slide in here to just be sort of the kind of a cheat sheet slide. So under Title IX, 2 areas. You can file a lawsuit. You do it in federal court. You can ask for monetary damages or injunction or both. Injunction means you ask the court to tell the school to stop doing something. Generally, it's stop enforcing your policies. It requires those three things: actual notice to an employee with authority and deliberate indifference, lawsuit, administrative action, initiated by the Office of Civil Rights. Voluntary compliance is what they're looking for. If we don't comply, they can issue findings against us. Those findings could result in our losing federal funding support, or they may kick it over to their big brother who carries the badges and the guns, called the Department of Justice. And the Department of Justice can file a lawsuit against us for failing to comply with federal law. It requires actual or constructive notice, a new or should have known standard, and then it requires these four things: investigate, end harassment, remedy impact, and prevent the recurrence. Here's our 9 commandments that are part of Title IX mandated. That our investigations need to be thorough, reliable, and impartial. That the process that we apply, and by the way, all these pieces of language directly from the 2001 guidance and the Dear Colleague letter. That the process must be prompt, effective, and equitable, and that our remedies must be designed to end the discrimination, prevent the recurrence, and remedy the effects on the victim. My watch is not working, so I've got my phone here. I want to see how I'm doing for time. Okay, good. So that's our 9 commandments to be in compliance with Title IX. Here's your next check sheet. This, again, was directly from the 2001 guidance and reinforced in the Dear Colleague letter. The compliance requirements are this: non-discrimination statement. And they go on with a lot of details, by the way, about what needs to be reflected in a non-discrimination statement. What I recommend to schools is that you have on all your publications, and by the way, they do say every publication, every communication to students, outside entities, parents, unions, for some reason they mention unions, is that you have a statement that your school does not discriminate in education or employment, and then under that you've got the citation to your website that's got, the Title IX piece, the ADA piece, the Title VII piece, because all these laws require notification. But here's the sad thing: when I went on every one of your websites, I couldn't find a non-discrimination statement anywhere. And I would honestly like to see, at a minimum, a statement on your very front page. Now, I know front page space is like gold, but if you have to take away one of the pictures of a football player and put it in there, do it. That our reporting and response protocol must be effective, that our grievance procedures are appropriate to our school, as well as to creating a process that has the integrity, that our investigations are fair and equitable, as are the remedies, and that they're designed to prevent the recurrence. Training is critical. I was the attorney for the College of Notre Dame, which was one of the first schools that was selected to be part of the OCR's new emphasis on voluntary compliance reviews. Prior to the Dear Colleague letter and the increasing prominence of of Title IX in the Department of Education, OCR would only visit our campuses if someone had filed a complaint. So it was always complaint driven. They would come in with a complaint as the basis, and they would do a review of what we had done. With the advent of the Dear Colleague letter was a very huge beefing up of OCR taking a look at our schools. And they go, we're doing this new cool thing. It's called voluntary compliance reviews. And before you think that I will volunteer for that, please recognize it is not voluntary on your part. It is voluntary on their part. They will call you and go, you've been chosen. You get to participate with us. And I watched the College of Notre Dame spending what they told me was more than 10,000 human resource hours gathering information. These were the absolute things that they asked for in that. And the training, they wanted to see the training for the last 10 years. Who was trained, what groups were trained, what materials were used, who did the training. They asked to see every report of sex or gender misconduct, from harassment up through non-consensual penetration. They want to know how it was handled, what was the timing on how it was handled, what was the outcome, how did it meet the standard of reasonably preventing a recurrence. So it was a hugely onerous process, which resulted in a 15-page letter that they required to be signed by the board for compliance with things that they had seen. And to give you an idea about how strongly OCR feels about this, I was working with their general counsel on it. Their general counsel said, it's time to stop. When they presented them with a 15-page letter, you said this was voluntary, that we hadn't done anything wrong, that you just chose us, and now you're giving us this 15-page compliance requirements that included all this training and climate reviews and discussions related to that. And he goes, I'm not going to go to the board and tell them to do that. We haven't done anything wrong. And in the OCR, very nicely, said, we just want to remind you that we also have the authority to review all of your ADA requirements, because that falls under OCR as well. And we gathered the information that we thought was important, but on second thought, maybe what we need to do is actually have interviews with every faculty and staff member and student about the climate. We did not issue a finding in this case, but boy, it's certainly possible that one could be. So it was very obvious. I mean, as an attorney, I call that a contract of adhesion. It's like you don't have any choice in it. So they've really engaged in this focus. And I pulled this from that discussion, which was directly from the 2001 guidance. So and by the way, these next slides all go along with each of these pieces here. Policies and procedures. Policies should clearly define expected prohibited conduct. Don't make it ambiguous. If you've got a term called sexual assault, recognize a couple of things. Number one, that's also a criminal code term. And if you charge a student with something that's also termed under your criminal code, you can expect that that student will come in prepared to defend themselves, accompanied by their attorney, who is saying to you as a higher education institution, what business do you have charging my son or daughter with a crime? Of course, you're going to say, no. See, this is our policy, and we define it differently. And the attorney's going to go, well, that may seem that way to you, but sexual assault is a crime in the state of Oregon. And so if you're going to find them responsible for this, I'm not letting you get away with this preponderance standard stuff. No. You're going to use the same standard that the law enforcement would if you're going to charge them with a crime. So when we're talking about policies and procedures, don't make it subject to interpretation. Make it easy to understand. Again, think about being that 21-year-old student at your institution and you're trying to find the assistance for your friend. I and my two partners developed a document that's a model policy, and we have 4 elements in it. We have sexual harassment, of course, non-consensual sexual contact. It has intent as part of it, it has non-consent, and it has any contact of a sexual nature. Third one, non-consensual sexual intercourse or non-consensual sexual penetration. Again, leaving nothing to interpretation. And then finally, the last area is sexual exploitation, which has a number of pieces in it, including exposing oneself or requiring someone else to expose themselves, videotaping of another individual in a sexual way. So sexual-based bullying or stalking would all fall under sexual exploitation. Make it clear, make it easy. You'll see on one of my advice pieces, bullet it. Don't make, and I challenge you on this too. Go to your policies, the ones that have like the long paragraph that honestly I'm sure are beautifully written. You're not going to pull all the important pieces out of it. give you an example. Non-consensual sexual contact, here's what I like to have under it. Contact of a sexual, intentional contact without consent of a sexual nature between two individuals. And then you have a two-sentence paragraph that says what sexual contact is. But it's that easy. So I don't have to read the long paragraph that beautifully describes it, but I've gotten bored by the time it's in 3 sentences. There are more devoted to engaging in criminal investigation versus institutional protocol. It varies so greatly. But the most important thing is we know that only 5% of someone who's a victim of some form of sexual violence are willing to go to campus law enforcement. We're missing 95% of our students. If that is your very first contact place on your list for filing a grievance, you've lost a lot of your people. So make it easy. I like to begin with individuals who have privilege and may maintain absolute confidentiality, include A, B, C, D, on campus, off campus. And then from there, I identify it where a student can make a complaint or make a report. So make it easy. What procedures should provide for equitable remedying of complaints? List for our students what kind of remedies the college or university is capable of providing for an individual who's a victim of it. We sat down one afternoon over a glass of wine and came up with 40, and it was only one glass of wine. So recognize, of course, your policies should be regularly updated and revised. OCR will look for that. They will want to know when it was most recently revised. When we talk about the prompt and effective elements, this is what OCR says. Once we have notice, we have a legal duty to conduct an investigation. That duty is absolute. The investigation, little I, preliminary, or big I, comprehensive. Typically, one follows the other, but it must be done. The promptness requirement, 30 to 60 days. This was the goal, and when I work with OCR individuals, they say, we have a little bit of flexibility. It's around holidays or spring break, but we don't give schools a break over the summer vacation. We expect that the 60-day adherence is applied. I do want to mention here that there's going to be circumstances in which a behavior is criminal in nature, in which either campus law enforcement or local law enforcement needs to gather evidence and begin preliminary investigation. DCL tells us that generally is a 3 to 10 day window. They go on to say there are circumstances in which it's been extended further. Let me tell you what that circumstance was. Eastern Michigan University. A young woman was raped, murdered, and beheaded in her residence hall room. They gave law enforcement 14 days. But that has been the largest extent of time I have seen OCR grant to an institution. So unless you have that kind of situation, you need to be working within that 3 to 10 day window in which you will not engage in investigation in lieu of police investigation gathering. During that time, however, the remedial support must be ongoing. Again, the effectiveness requirement are the things that we talked about, and this is what will be measured on: stopping the behavior and violence, removing the impact, and then the sanctions in our response are reasonably calculated to prevent the recurrence. And by the way, I want you to think about this in terms of the reasonably calculated to prevent the recurrence. I want you to think about this in terms of the professor who's found in violation of sexually harassing a student. Because like the University of Iowa, who just 8 months ago paid out $10 million to a student who was sexually harassed in a class, when the university's argument was there had been no complaints made, but when they began the investigation, it was obvious that for decades, students knew and warned each other, And it was common knowledge within the department that if a female student took this guy's class, they were going to likely be the subject of a sexually charged, hostile learning environment. And after the lawsuit came to the University of Iowa, they settled it for $10 million. And one of the reasons they settled it so high is the charge was that complaint was against the professor and the university, and the professor committed suicide. The complaint went forward against his estate, and as part of the settlement, the university agreed to pay that amount of money so that they would not continue the complaint against the estate. Our grievance procedures. Here's where so many of our schools fail to provide this kind of detail. And again, these are checklists from OCR. What constitutes a grievance? Who can file it? Do you have limits for submitting the grievance? The correct answer to that is no. What is your prompt and effective response when you learn about it? What happens? I'm a friend, I'm looking on your site, I want to know what is going to happen when it gets reported. I want you to tell me that information. Specify the availability of assistance that's available. Do you have victims advocates? Do you have trained individuals within your counseling center that can provide the assistance? Number and levels of steps in your process, that we protect an individual who's grieved from retaliation, and of course the fact that either party has a right to appeal the outcome.
We're at your 45 minutes.
Thank you. In terms of your Title IX coordinator, of course, you know clearly by now that all schools are required to have a Title IX coordinator who's someone more than just in name only. That they have that 100-foot view that's responsible for promoting an environment free of bias. And then these are the elements that your Title IX coordinator must be able to fulfill. That they oversee the complaint procedures, even if they typically are not the on-the-ground person. Your deputy coordinators are more likely to be the on-the-ground person implementing the procedures, but the oversight of it must be done with the knowledge of the Title IX coordinator. Public notice who your Title IX coordinator is. Again, on most of your sites, didn't see it. Didn't see that is always an alternative for reporting. The Title IX coordinator, and what OCR says is name. Because we said to them, can't you just say Title IX coordinator and contact information? They said, no, we want name. They are responsible to ensure that the training is done, and then they're the person that's going to be responsible for doing that technical assistance and working closely with your campus law enforcement. Now, I want to talk about notice and reporting requirements as we move into the last parts of this, and because it gets confusing. And let's use the term mandatory reporters. Under Clery Act, they have campus security authorities, which I would guess all of you are. See, you're going to get new business cards now. It's going to have campus, dean of students, campus security authority, and responsible employee. Because under Title IX, they call them responsible employees. And individuals who are one or both of these need to know what has to be reported, how is it to be reported, and to whom is it to be reported. So under Title IX, remember, actual and constructive notice. So in the context of this, if a responsible employee knew or should have known about sexual harassment or violence, reporting is required. And again, they use this actual or constructive notice. Actual notice are things like this. Someone files a grievance. Someone notifies a coordinator or deputy. They make a complaint to campus police. A staff member witnesses harassment. And OCR says even indirect is still considered actual notice if we learn things. A lot of conversations recently about the Clothesline Project, about the Take Back the Night, about speaking out. And it gets very confusing when what we hear from OCR is this is actual notice. And therefore, you need to address it appropriately. Constructive notice is the situation that I talked about at the University of Iowa, that they just settled the case. If it's pervasive enough that everyone knows about it, then it's going to be something that the institution must be responsive to. That we should have known of incidents if based on, if someone that has a reporting duty failed to uphold that duty. And it's as if the responsible employee was representing the institution. This is what OCR says a responsible employee is. Again, we should wear a bright light. There isn't. A bright line, there isn't. But they say someone who has the authority to take remedial action. So those would be those of you in probably the upper administrative levels who have the authority to stop the behavior and trigger a process. But then they go, or if you have a duty to report the harassment, or, and here's the catch-all, someone a student could reasonably believe has that authority. And that's where it starts to take in pretty much everyone. And interestingly enough, in my conversations with schools, that includes things like your residence hall housekeeping staff. Because students tell me oftentimes that's the person they talk to. They don't think they have the authority to take action, but they very much feel like they have the authority, that those people have authority to report it. So when we talk about that, here's what we need to incorporate in training for responsible employee. It's different from the Title IX training where we go, and here's sexual harassment. Oh, Camille, I think you look just really wonderful today. I hope you'll go out to dinner with me tonight, and I'll give you a promotion. And then, you know, it cuts to the moderator who goes, and that is sexual harassment in the workplace. I don't want you to do any of that. What you need to do is let people who are responsible employees know that they are and how to respond appropriately. Typically what we do, like for faculty or for RAs, is we make sure we've got that brochure that we can print off the information from our website to let people know about the resources and what the process looks like and where they can have privileged confidential assistance and support and who's going to know about it. But we've got to let responsible employees know what they're required to tell. Do they have to knock over all the dominoes? Do they have to give the names of the complaining party and the alleged perpetrator? Or do they report the incident only? That's going to be determined by your institution, and it's a training issue. Can they keep the identity of the individuals private? They need to, a responsible employee needs to know, who do I tell? Do I tell my dean? Do I tell my hall director? Do I call the Title IX officer? Do I go to the deputy assigned in my area? Don't play hide the ball with who they're supposed to tell. How do they tell? Do they have to write it in a memo? Can they pick up the phone? Is there a form? And then when to tell. In terms of under the Clery Act, campus security authorities, the first two, of course, law enforcement, but then we get into this mushy area. Any official who has significant responsibility for student and campus activities. And I'm trying to think of the woman's name. Dolores Stafford is one of the top Clery Act people in the country. She was previously the chief of police at, I want to say, George Washington University. And now she does consulting on Clery Act. And Dolores says, when I work with schools, I go, these are artificial barriers. Everyone needs to file a Clery report, including confidential privileged sources, because all you tell is the date, the category of crime, the location, which is a category too. It's on campus, off campus, non-campus, or on campus residential. And then you identify, was it by a hate or bias crime, and you send it off. It never identifies the identity of the person. Who's exempted from reporting under the law, of course, clergy, therapists, and medical personnel, although again, Dolores said, I ask them all to do it because it gives us a better snapshot of the Clery statistics. Here's the things that must be reported. Basically, I went over all of those with you. I want to conclude this by 3 sets of slides that I think are important for those of you in top leadership. I put these 2 slides together, by the way, a year ago. I met with 300 college and university presidents and Vice President Joe Biden. And one of the things they asked me to conclude is, what should I tell the presidents they should be concerned about ensuring happens? These 2 next slides are from that list. Number 1, that policies are audited. And that incorporates student or employee harassment policies. My hope is they would be the same. There's no reason that we don't have community-based sexual misconduct policies that apply across the board. But that someone takes a look at our Code of Student Conduct policy and makes determinations of how does that intermesh with circumstances in which the behavior would rise to that sex or gender discrimination and needs to be addressed under the mandates of Title IX. It may be addressed through your campus code of conduct if you can meet the prompt and effective standard for it. If you have a violence policy, bullying or stalking, harassment, discrimination. So the long set of policies that I asked the presidents to have someone audit them to see if they're readable, are they in compliance? And then that the presidents require an annual report, and that report identifies what are the scope of the sex and gender-based issues on our campus. Are there areas in which it's systemic, departments or organizations or residence halls where that behavior is systemic, and what have we done about it? What kind of responses are we engaging in? And then do we see trends? So that your chief officer is aware of what we need to be concerned about. Then they've got to support the individuals that are doing it. There is lone voices out there among Title IX officers, among victims advocates, among deans of students who are saying, we've got a problem here. We've got to figure out how to fix it, and we don't think the president knows about it or cares about it. And so support the prevention initiatives to train individuals, to publish resources, to recognize the priority for prompt and effective responses, and then build those relationships external to your community with victim services resources, with community law enforcement, and then community leaders. Let them know what we're doing and what our priorities are. The final next 2 are your checklists for Title IX compliance. Easy peasy stuff. Take it, use it as your checklist. Do you have a non-discrimination statement? Is it everywhere? Is the contact information from your Title IX administrator on there? What about your policies? Do they tell how to, what the protocol is and who to report to? Do they identify appropriate behavior in a way that doesn't make the person read the rest of the paragraph to figure out if this applies to me? Identify what your grievance procedures look like and what the appeal standards are. And then finally, notice of information outcome. People need to know in advance if they're going to be entitled to know not only the determination, but what the rationale and what the sanction was, because that's going to have an impact on their willingness to participate. That your procedures must be prompt and equitable, that training occurs for all constituency, that your investigations are fair ones and they're equitable and complete, that your remedies are also effective, and that you have specific action designed to prevent the recurrence. What does that mean on your campus? How do you enact it? The next 2 slides are from my partners and I. We put together pointers that we think is important. These are not things that are required by law. These are things when we work with our clients, we say to you, these represent some best practices. List your responsible employees in a clear policy. communicate the reporting requirements to everybody. We've prepared a template, and if the schools are interested, I'd be happy to give you that template. But like with all my clients, I write the template for the president, but that identifies reporting requirements. What's a responsible employee for Title IX? What does that mean? And how are they responsive to that? Who are campus security authorities? These are federal laws and mandates. And then finally, what's the reporting requirements within Oregon for reporting abuse of minors? And what I recommended to presidents from all across the country is if your state law doesn't address it, then you need to go to your board and you need to have a board-created mandate for reporting abuse of minors. And then that information needs to have what to share, who to share, and how to share. The 3-click rule, of course. Do it on your phones. I see a lot of you on your phones now. Go to your website. See if your roommate had come in or your best friend and they were sexually assaulted, or they had been a victim of ongoing harassment in an education environment. See if within 3 clicks you can tell them where to go, what they can expect, and what kind of remedial support's available for them. Bullet your policies. Don't write them in paragraphs. We already know students don't read them. They're much more likely to if they're in brief bullets. Equitable processes for employee discrimination and complaints, not just those involving the students. We like investigation in teams of 2 or 3, and then ideally a strategy team that incorporates your Title IX officer. Be as victim sensitive in your processes as absolutely possible, recognizing that victim sensitivity is not the intention of creating bias, but with the recognition that you have an individual who is experiencing discriminatory behavior within your education environment, and the importance of the sensitivity to that. Don't let it be overshadowed by your fear about due process. And then do equity through equity. Recognize that from the beginning that you get information, your response, your protocols, your follow-through must be done with equity in mind, and that is fair under the circumstances. So some of the advice I'll give you will be grounded in law, and others will be challenging you to say, is this an equitable response to make for the parties involved? And we're at the conclusion on that. I think we've, as I look at my wrist with my Title IX bracelet and nothing else on it,
It's central.
good. We've got almost a half hour now, but I'd be happy to entertain questions. Any? I'm sure there's tons.
Well, my first question is.
Why did I pick on you, right?
No. Will we be able to have an opportunity to get a copy of the
You absolutely will. Yeah, that's
My
going
arm
to
got
be.
tired.
Did you?
Very good.
Good, good. Well, no, I talked to Jessica about that, and there she is. And your plan is to send it out to everyone afterwards, right?
I'll send out the PowerPoint and the evaluation.
You know, there's a document, and I don't know if you're interested in it or not, and I will, in fact, I'll ask Jessica if she will make sure she keeps the list so that I send this to her, but one of the things I like to share with groups is when I come across a document or a protocol that I think is particularly a best practice. I always like, I request permission from the school to share it. And the University of Northern Iowa has put together it's a multi-page form, but my understanding, I believe, is they're getting it online so it can be shared. If you've got a database, by the way, having a database is a really good way to share among individuals that are responsible for either investigating or part of a strategy team. But anyway, the University of Northern Iowa takes the system through the first notice that they get about sex or gender misconduct. And of course it identifies who was the recipient of the information. And then that form follows the process. So each step in the process is identified who was responsible for doing the remedial pieces, what was the date or the timing on it, when was the Title IX officer notified. I think it's just terrific. So if you guys would like us to make sure we send that out to you, we'd be glad to do that. One of the other forms that I've got that I think is really helpful is a timeline form. Because I'm really uncomfortable when our policies say, we're going to do this in 5 days, we're going to do this in 10 days. Instead, I like to indicate that the process will be done promptly and effectively. That translates into generally a 60-day to resolution. But each case, the parties will be involved, will be notified of what the actual timeline that will be applied to that case will look like. One of the things one of our friends did a study and discovered that there are more lawsuits against institutions that have been triggered as a result of their lack of being kept informed and knowledgeable about what the institution is doing than there are lawsuits because they're unhappy with the outcome. So I think from my standpoint, that is a really important lesson that we never overlook the humanity that's absolutely essential in when we're conducting these investigations and engaging in the approach, that both the accused individual and the complaining party are kept informed about where we are, what we're doing, what they're entitled to see at various points. And for example, one of my schools had a protocol where they took the complaint from the individual, and then the next contact was with the accused, and they gave the accused the written complaint. And what do you get back from that? You get the response to the written complaint. And so if any of you are doing that, I would really encourage you to rethink it, because what I want, number one, what I want to see you do, I talk about strategy a lot, is if you receive a complaint, strategy begins there. Strategy begins at that point with whoever has been the designated person. Oftentimes, it's not going to even involve your investigators yet. Strategy would begin, let's say it involves a faculty member and a student. The strategy piece is going to be involving either the deputy for human resources and the deputy for students issues and a Title IX officer to sit down and say, what do we have? What is the urgency? What is the seriousness? If everything were taken at face value, would this violate one of our policies? If the answer to those elements, it's a gatekeeping function. It's a really critical gatekeeping function. Because then from that point would be the determination of a handoff to the investigators. And again, I like minimum of 2. One to be the primary interviewer and one to take notes, but also be a less active participant, but having the opportunity to ask for clarification, to obtain additional information and review it. I like having interview teams with both genders. I think it's important that part of your strategy is, am I the most effective person to be leading the questioning in the investigation piece? I like when you go into investigations, having done the strategy initially, to say, what are the policy elements, and parse those out. So you're making a determination, let's say, was there intent, and what represented intent? Was there consent? What suggested there might have been or there might not have been consent? Were there other individuals that we need to get information from? Certainly, we're going to ask those questions of the 2 primary parties, but don't stop there. As part of your strategy, think about the big picture. Who might else give us information that would be beneficial? And also ask the questions, what do we need in terms of documentary information? Is it important if we know what time someone used their swipe card to get into a building? Might there be security cameras that we would want to see that would lend us information or support? Is there text messages? We had a situation where a student alleged that she was being sent all these text messages from a professor. And they did their strategy. They were very salacious text messages, and they did the strategy on it and talked about, you know, who they wanted to talk to first and what was the best information. By the way, talking to the accused individual is not necessarily your second interview. That's why I want you to be strategic about it. But so they called me and they said, you know, how can we verify this or get this information? And I said, well, when you're talking to the professor, why don't you just say, can I see your phone? And he said, what if he says no? Well, that's a piece of information in itself. Doesn't necessarily mean they're on there. They absolutely have a right not to show you their phone, but don't hesitate to ask the questions. Why would you not ask that question? So I like engaging in the approach in a very deliberate and strategic kind of way. I'm very, very wedded to our systems and processes being transparent, that we, you know, can answer questions to the absolute extent possible, that unless there is something that precludes us by law, and typically the law that we deal with, the law that talks about, I know that there's been discussions related to informing an individual of the outcome and what does that mean, and particularly what does that mean in terms of when it is an employee and a student. And when it's let me back up just a minute, when it's a student to student, the communication has as its protection law, FERPA. And as the Dear Colleague letter made clear, when there is any kind of a conflict between sharing information, because it's protected by FERPA, and the importance of informing under Title IX, Title IX prevails over FERPA. So you need to be asking the questions, are there laws that create that prohibition? I would argue that in circumstances involving a faculty or staff member, unless you are absolutely prohibited by state law, that would be your first threshold to be concerned about. But I think the other piece to that is equity demands the opportunities for both parties to have information related to them. Remediation for an individual who has been the target of a discriminatory harassment would suggest that that individual has sufficient information to make an appeal. Because, by the way, the opportunities for appeal, which are mandated under Title IX, remember, Title IX is not a student-to-student law. That means if your faculty handbook allows a faculty member to have 5 levels of appeal, and the complaint has been brought by a student, the student is entitled to 5 levels of appeal as well. And so when we're balancing the rights, I want to make certain that you're doing so within the recognition that unless you have absolute prohibitions, that you have a strong, there's a two-piece argument. There's the public policy argument piece that suggests to me if we're engaging in an equitable process, why wouldn't we share with an individual who has been a victim of an action the outcome, the sanction-related outcome that would have a direct impact on them, their decisions to remain in the process, our need to provide perhaps additional remediation support or pieces. And that's more a public policy argument of the why wouldn't you? But from a legal standpoint, I would find it very difficult for us to comply with the federal law of Title IX without providing the sanctioning base of the outcome that directly related to the complaining party. Now, so what pieces might not? Well, if someone's been required to go to counseling, or someone's been required to attend anger management, or someone's required to do a program for their department. That's not going to have a specific impact on an individual who has been the victim of a case. Now, we're talking in these circumstances, by the way, only harassing discrimination, sex or gender-based harassment. Because when it goes up into the arena of the non-consensual contact or non-consensual penetration, that's a crime. That falls under Clery. Clery says outcome consists of three things: the determination, the sanction, and the rationale. So that goes off the table. If we're talking about circumstances involving any kind of penetration or any kind of non-consensual physical contact, it's going to fall in the crime category, and we know that we have to provide all the information. If it's a circumstance involving a hostile learning environment, a sexually harassing kind of environment, then the law is less clear because you don't have the Clery mandate on it. But from my standpoint, we're still talking about the equity elements of Title IX. And unless we can make a strong argument that it's equitable to not share a sanction, I think we become very vulnerable for it from a legal standpoint. Taking on our
Definition of who is an employee between students and employees, and then, we have folks who are on campus for one class. They instruct a single recreational organization.
Yeah.
So the obligation to make sure that everybody on the campus, and that definition, it just makes me nervous.
It does.
It's so broad.
What Michelle said is the idea of responsible employee and the water goes, and the vastness of that can be troubling, can be a concern. And what you described is a person that comes to campus one afternoon a week and teaches a class. And I know I've got community colleges here. Do I? Thought I had a community college here. I hear this a lot at community colleges because generally 70% of their faculty are adjunct faculty. And I would go back to you in that kind of a situation and say, do you think the student that's in that class is going to view that individual differently? I would argue that they don't, that a student doesn't usually go, okay, tenure, check, full time, check. No, you're a professor. It doesn't matter to me if you're here 2 hours a week. You're my professor. And I believe you represent the institution to some degree. So I don't think we can give a pass to adjunct professors, which is why I think it's absolutely critical from your top level. Communication is made, identifying people's responsibilities for reporting. What does that look like? I don't want to be training all of our professors in how to engage in counseling support or be the one that's responsible to tell a student, here's all your resources and here's where you can go. At a minimum, though, I think they should be provided the information with the resources on it, and that adjunct faculty member has been instructed who they make that report to. Do they call the deputy coordinator for faculty affairs, if there is one? Do they call the dean? But they can't keep it here, because keeping it here means the next person that experiences it does so after the university's been put on notice. She said, do students fall under the category of responsible employees if they're a student employee? And I said sort of, and I mean yes. Because remember that. Well, yeah. A student is not going to expect that their RA has the ability or the authority to engage in remedial support structures for them. But they would have the expectation that as an employee, the RA has obligations to report to their hall director or to their area coordinator areas of concern. I think that comes with the territory of being a student employee. is the reporting elements, not the remedial pieces, but the reporting elements. And for each institution, they need to make that determination of, do are RAs required to give the name and all the details of both the complaining party and the accused, or do the RAs have a little bit more flexibility of being mandated to report what they learn, but unless or until the information would rise to that area of concern or represent a pattern, the identity of the individual could remain private. And that's an institutional decision. I had a hand up back here, and I want to get him because I skipped over you.
Saunnie, late in your presentation, you alluded to the idea that some programs like the Clothesline Project and Take Back the Night can now be looked at as actual notice.
Yeah, I'm starting to see that, a lot of discussions on the listservs about that. And we actually talked to the people at OCR, and they said that if an individual, and I want you to understand, this is not necessarily my comfort level with this, but that if an individual that's a responsible employee learns about a sex-based misconduct that occurred within our context, that we have an obligation to, A, make the Title IX officer aware of that, and address it appropriately. Again, from my standpoint, that's why I like you don't have to knock over all the dominoes at the same time, so it wouldn't be a matter of calling the Title IX officer and saying, so Sue Smith shared this story, but it would be a matter of saying, I learned this story last night, this is the context for us, we need to talk through it. And primarily, it's that preventing the recurrence to the individual or to the campus that OCR has a lot of concern about. I find it particularly troubling because what I'm seeing is advice, and actually advice from my partner Brett, suggesting that people administrators like all of you that have previously participated and done so in support for individuals who are survivors, particularly survivors of sexual assault, is what we encounter at the Take Back the Night and the Clothesline projects, that they avoid being there for that very reason. So I think it's something that schools need to talk about. I would never want to do away with it, and I think that we can find ways through discussion among our groups of the best ways to do that, to A, provide support, but B, be in compliance.
In what we're talking about, my biggest concern is that students, you talked about making a complaint or asking schools to take action. And my concern is that students are going to be we're interpreting them making a complaint when all they're doing is actually sharing their story, and
Sure.
they're then going to be violating them further by taking action when they're in school.
Well, and again, I come back to your terminology about taking action. I think that we don't parse the word, when a student shares their story with someone within our community, unless that person has privilege conferred by the state, then that information must be shared with a Title IX officer. A, it's the only way that your institution can begin to identify where there may be patterns of behavior and systemic issues. But it also is a balancing of, at that point, it's not a matter of the Title IX officer calling that person in and saying, this is what you need to do, and we're putting it through a hearing process. That's, I call that sort of a runaway train approach that we would never want to do. So if a person shares their story, that's why I don't like these things to be complaint driven, but they're notice driven. And the notice may be actual or constructive. And when we receive notice, we have an obligation to inform that individual that there are resources of support, that they always have a right not to participate. They don't always have a right for other people not to know. That would be kept very tight. And that's why I like to use the word private or privacy as opposed to confidentiality. and we explain the context within which the information may be shared. And again, unless the identity of an individual is a critical element to moving in a direction, I'm always in favor of not providing the identity of the individual who has put us on notice initially unless they want it to be. It doesn't mean that we have 100% opportunity to maintain that, but we may. I mean, there are many, many circumstances, most circumstances, in which we can absolutely honor an individual's request not to have their name identified, because they always have a right not to participate. So unless knowing their identity would somehow make the campus safer or enable us to do more in providing remedial support for them that they wish, then we don't have a need to know their identity. So maintaining the privacy of the identity is something that we can do except in pretty extreme cases. Mm-hmm.
I had a question going back to Michelle's question about students. What about volunteers, such as ambassadors or multicultural center council members? How would you address?
Okay, she asked the question, what about individuals that are sort of peripheral to the campus, like volunteers or campus ambassadors or volunteer students in a crisis center? And if what we're doing is applying the law of responsible employee, we got that little key word of employee there. While we may ask that they report, there's not a legal mandate for that to happen.
Still with students. So my question is, what are the limitations? Is it just during their time when they're employees? So if they're working at the library and someone discloses something to them, is that their obligation? Or when they're off campus hanging out with them, one of their friends discloses, do we have an expectation that they're still a university employee?
Well, and that becomes tough. And let me tell you why it's tough. I don't know if you heard what she said. She said, does that just mean like when you're in the context of doing your job that you've got that as an obligation? And here's where you engage in that kind of legal analysis piece, is going back to that actual or constructive notice. If as the librarian, you're at a party.
A student. It's so a student worker.
Oh, a student worker.
At the library,
At the library.
right.
Student worker at the library.
At a party.
At a party, I would say no. No. In fact, the student worker at the library, number one, the likelihood of them being informed in their role as a student worker at the library is probably minimal. You think they do?
Just in pure disclosure, those things happen all the time.
Oh,
all these
sure. But in their role as a student librarian,
Another student library person discloses.
mentions it to them. It would depend on the expectations. Do they have, is there required, to go to that second bullet, are they required to report harassment or other forms of misconduct? And generally within that work environment, I mean, Title VII generally requires that you report to your supervisor. And so Title IX would, that's why Title VII and Title IX, instead of me saying, well, that's either this or this, I say the answer is yes, because they're intertwined. Now, the student librarian at a party, I would say no. But again, I want to go back to, when I was talking about the legal analysis, the actual or constructive notice. If the institution either creates by its policies and procedures a harassing environment, we can be held responsible for it. And the case that I always refer to when I'm talking about creating that context for harassment is the Simpson-Gilmore versus the University of Colorado Boulder. And that was a case of just really briefly, the premise on the case was that University of Colorado Boulder had a tremendously successful football program. And it was in large part predicated on the fact that they were so successful in their recruiting program, because they would bring in young recruits from high schools. They would pair them with a campus ambassador, female, and a football player, whose job was to show them a good time of the weekend. And a good time translated to sex, marijuana, and alcohol. And Ms. Simpson and Ms. Gilmore were asked if they would host one of the parties by a campus ambassador. They'd be bringing over maybe 4 or 5 recruits, and instead 24 people showed up. And there was a lot of alcohol, and Ms. Simpson and Gilmore, very intoxicated, went into their room, locked the door, and Lisa Simpson woke up about an hour or so later. She was stripped naked. She was being sexually assaulted by 3 men. She looked over, and her roommate, Ann Gilmore, was completely incapacitated. She was passed out. And she was also stripped naked and being sexually assaulted by 3 men. These 2 women did never inform the University of Colorado Boulder that this had happened. So remember, they failed the actual notice to a school employee who had authority to take action and demonstrate deliberate indifference. Wow, they missed all the elements for a lawsuit. But when they filed their lawsuit, and of course they lost on a summary judgment motion initially and appealed, the court's response was to the University of Colorado, "Are you kidding me? Serious?" And it was like the Saturday Night Live thing. Really? Really, University of Colorado? For the last 2 decades, you have brought young men in. They have spent the weekend having sex and getting drunk, and everybody knows about it. And you're going to say that you didn't have actual notice and that you didn't demonstrate deliberate indifference because these 2 young women who were victims of it, like a litany of other young women over the course of the last 20 years, have been victims because they didn't tell you. You're going to hide behind the fact that they didn't do that, and therefore, how could you demonstrate deliberate indifference? You didn't know that it had happened. Yes, you did. It's happened for 20 years. And so the court in that particular case used that. You created the context for the harassment. People knew about it. So in those situations, it pulls back to your student situation. If what a student hears at a party is, wow, down the street at the hockey club house, girls are getting sexually assaulted there all the time, I would say that student probably should be reporting that to the supervisor. Not a hard and fast rule, generally no, but I think when there's circumstances in which it's systemic within pockets in your institution, the answer is yes.
And also we're at time.
Okay, that's what.
Can I ask you to return to the Take Back the Night activity? And you know that it's on the agenda, you know that the speak out session always occurs at a particular time. You've heard and possibly witnessed in the past yourself, the kinds of things that are described at the speak out session. And you've decided that you want to be supportive of the event, but you can't, on the other hand, be there for the session because you might hear something that you would then have to follow up on. And all of the other mandatory reporters that want to support the event would normally be there, agree with you, and so they all leave at the same time. Did you say that was actually a way to be supportive of the event and also avoid being put in a situation where you overhear something that you need to follow up on?
I said that is not the approach that I recommend, but it is the approach that I'm seeing more and more often, including I heard that or saw that on a listserv from my partner Brett, who said that his recommendation is individuals who are mandatory reporters engage in a discussion with the participants in advance to say, I will not be present during your telling the stories in order to avoid the need to report it. I think institutions need to find a balance for that, frankly. From my standpoint, the only time I would become concerned about it is if we miss information that could protect the next victim. So that is not my recommendation, no. I think institutions need to explore it though, and not have it happen by default. It be one way or the other, and have those conversations with the students. You know, we have degrees of obligations for it, but for heaven's sakes, let's not overlook the students and say, what are the benefits, what are the risks, what is the best way to do this? I'm really big on weighing benefits and risks, and unless the law is very clear and tells us that we need to do something that doesn't feel right to us, then I like to do the right thing instead. And sometimes it is instead, and sometimes it is the law. But when it's a gray area, I want us to have the conversation about it, the discussions, and make a determination of what's the most effective way we can approach it.
And we're gonna be